Welcome back to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. We're pleased to welcome Mark Mix, president of the National Right to Work Committee and its Legal Defense Foundation. Mark, welcome to the show. Good
to be with you today. Thanks for the opportunity.
Mark, start by giving us an overview of the National Right to Work Committee and the Legal Defense Foundation. Who are you guys?
Well, we are charitable organizations, one charitable organization that provides free legal aid to workers. We've been around since 1968 as the National Right to Work Legal Defense Foundation. We represent employees whose rights have been violated by compulsory unionism agreements. We've gone to the United States Supreme Court 17 times.
Wow.
We have represented over 500,000 workers in class action lawsuits across the country. We've been in state court and federal court, the National Labor Relations Board, and as I mentioned, the U.S. Supreme Court several times. The mission of the foundation is to make sure that workers have a way to fight back against the abuse of compulsory unionism. The National Right to Work Committee has been around since 1955, and the mission of the committee is to expand and defend right-to-work laws at the state level, and ultimately, to pass a national right-to-work law in Congress, overturning the labor policy that's been in effect for 80 years that allows union officials to have workers fired for simply failing to tender dues or fees.
Well, you sound like a man on a mission, and your organization's almost as old as I am. In the first half of our show, we talked to a self-employed home daycare operator in Minnesota, Jennifer Parrish. She described her ongoing battle to avoid being forced to pay union dues to the SEIU for representation she not only didn't want, but to pay for lobbying for policies directly inimical to her small business. Are attempts to forcibly unionize the self-employed part of a national trend?
Yeah, absolutely, Bill. This is kind of the final frontier for organized labor in the private sector. Obviously, their emphasis on government employment is real, and it's causing trouble all across the nation. But frankly, in the private sector, they're out there trying to organize daycare providers. They're out there trying to organize home health care providers. And Jennifer Parrish was a client of ours. With her courage to stand up and to be heard, we were able to strike down an executive order in Minnesota by Governor Dayton as unconstitutional. We filed another lawsuit on behalf of Jennifer and other providers in the state of Minnesota and continue to represent employees up there in a battle for them to fight back against this forced unionism scheme that's designed to take home daycare providers like Jennifer and force them into unions. I mean, Jennifer is a small business person. She runs a small business. And the notion that somehow the Service Employees International Union or any union can force her to pay a fee to speak, quote unquote, on her behalf is just, it's just wrong.
Well, Mark, what's the justification?
The justification is revenue, is dues money.
No, hold on. That's the reason, but what do they put forth publicly, and how do they justify the idea that they should organize a self-employed person against themselves?
Yeah. Well, the theory actually was discussed by the U.S. Supreme Court in a victory won on June 30th of last year in a case called Harris v. Quinn. That gives you a pretty good picture, Bill, of what really is at stake here and what's happening. The case that we brought was on behalf of 8 individuals, 3 of whom were being forced to pay a fee to the Service Employees International in Illinois in order to take care of their own children in their own home. The union's claim was very interesting. It was a novel one, and frankly, the Supreme Court didn't buy it. On a 5-4 decision, they struck this down, and so we're protecting literally millions of home health care providers across the country from being forced into these forced unionism schemes. And what the SEIU said, and what then Governor Rod Blagojevich did by signing an executive order back in 2002, I believe it was, 2003, saying that the Service Employees International, you could take a skim off of the Medicaid stipend that was being used to pay for the care of these disabled adult children. These are, I shouldn't say adult children, they're adults who are disabled that are living in their family homes. And what the union said was, we're going to take some of this money out of the stipend that's used for their care, and we're going to use it to, quote, speak on their behalf at the state capitol. We're going to lobby for more money for Medicaid for these people, and we're going to speak for them in Springfield.
This isn't a union. This is a political party.
That's exactly right. That's exactly right. And that's what the Supreme Court said, and that was our theory in the case, Bill. We said that, okay, these government unions are by definition lobbying government. They're seeking redress of their government. And that type of speech is political in nature. And so if it is political in nature, and if all they do is redress government, then the First Amendment would protect these people from being forced to pay anything to the union for this private organization to speak for them when it comes to government.
So have these efforts stopped?
Oh, certainly not. I mean, the fact that we stopped them in the U.S. Supreme Court and these schemes have been deemed to be political and protected by the First Amendment hasn't stopped them a bit. What they do now is in a couple of states, they've encouraged the state to make them the sole provider of, quote, training for these people. And as these people go into this mandatory training in order to participate in the Medicaid program, they are given a union sign-up sheet and given lobbying by the union officials during these training sessions to join the union.
That's pretty clever. So Jennifer described a pretty interesting scam where the person who burst into her house tried to get her to sign a card check that they told her was a petition. What's going on in the card check world? I know there's some kind of conflict between secret ballots and card checks.
Yeah, this is another kind of scheme by organized labor to address the issue that they're facing with the lack of union elections that are occurring across the country. The number of actual union certification elections that are managed by the National Labor Relations Board, which is a 5-member agency here in Washington that kind of controls labor management relations vis-a-vis the private sector. And one of the responses to this dramatic decline in the number of union certification elections is to adopt a organizing scheme called card check. And Bill, what they do there is they simply go out, and if they can convince someone by whatever means to sign this card, it's basically a 4x6 card that says, yeah, I'm interested in the union.
Mm-hmm.
And once you sign that card, union officials can use that as an affirmative vote for union certification. So what they'll do is they'll identify a bargaining unit and identify the targets, and they'll go out and get these cards signed, and then they'll present them to the employer and say, look, we have a majority of your workforce signed up that they say they want us to represent them, and therefore you must accept these cards and allow us to bargain on behalf of all the employees in your workplace.
Is that legal?
Yeah, well, it is. It's interesting. If the employer agrees to accept those cards, then everyone in that bargaining unit now is represented by that union and cannot speak to the employer on their own. The union has to be engaged in those communications. So what the employer would do, hopefully, if they know how to work this process, is they would say, no, I don't believe these cards are representative of the views of my workers, and I would like to have a secret ballot election. The employer is the only one that can request a secret ballot election under the current law. Union officials tried to change that back in 2010. There was a very contested battle in the U.S. Congress over a bill called, believe it or not, Bill, the Employee Free Choice Act. That's what it was called. What it would have done is it would have stopped and prohibited, basically, secret ballot elections for union certification.
Sounds more like the Employee No Choice Act.
Exactly, Bill. That's exactly right. And that bill was defeated late in that session, and it hasn't come back again from a legislative standpoint, but it's coming back through these executive orders, through these state actions, and through the regulation of the National Labor Relations Board. So they're still trying for it, and they know that that system works better than actually allowing workers to go behind the curtain and vote yes or no on whether they want to be part of a union.
Mark, share with us the story of the UAW's effort to hold on to monopoly bargaining privileges at the NTN Bauer plant in Alabama. That seemed like an unusual level of chicanery.
Oh, my goodness, Bill. This is a story that's ongoing, unfortunately. It's an amazing story. When people hear it, they just shake their heads. NTN is a ball bearing factory in Alabama. Alabama's a right-to-work state. But the UAW had been representing employees there since the 1970s. And finally, the employees looked around and said, you know, this is not working out. We don't want the union here anymore. We'd rather talk with the employer ourselves. And they found out that some of the non-union employees of other facilities of this company were actually doing better than they were. And so they tried to decertify the union. And that is an employee-led action that basically says we no longer want the representation of the union. And they had an election.
Okay.
They petitioned the National Labor Relations Board. The board decided this petition was accurate. And so they had an election, and the employees won. And the majority of the employees said, we do not want the union to represent us anymore.
Okay.
The union filed charges and said, no, these people are just tools of the management. We'd like a rerun. And the NLRB agreed, and so they had a second election. And the employees won again.
Okay.
The union objected and went to the NLRB and said this was all unfair. So they had a third election. This time, interestingly enough, Bill, the union won, but they won with 148 ballots cast when there was only 140 workers in the workforce.
Sounds like a North Korean election.
So the National Labor Relations Board had to throw that election out. So now we're at our fourth election, and the employees vote, I believe the vote was 80 to 52 to throw the union out. Again, a clear victory for the
Wow.
employees. And the unions, again, filed blocking charges to certify this election. The NLRB heard testimony about the election and agreed with the unions again. And believe it or not, there will be a fifth election coming up in the next couple of weeks, and there'll be a fifth election as to whether or not the UAW continues as the bargaining agent for these employees in this Alabama facility.
And the NLRB just lays down when the union asks.
Yeah, pretty much that's what's happened. You know, in this case, Ginger Estes, who's our lead plaintiff in this case, and some of her coworkers were really intimidated. They were called these names, just foul things. If you look at the affidavit in this case of actually what happened out there, where kind of the rubber meets the road, where these workers who are standing up for their rights, are faced with this coercion and this intimidation and the threatened violence that goes along with these type of elections. I mean, they even go after family dogs. I mean, this is where it gets really crazy. And the one thing that happens here, Bill, is their design of union officials and the union militants that do these types of things is designed to intimidate people to stand down. And if they can get one or two people to kind of capitulate, then the other people look around and say, I don't want anything to do with that, and they give up too. And that's why the Right to Work Foundation is so important, because we're able to give voice to these courageous workers that want to stand up and fight back.
Mark, more than 8 million Americans are employed in small businesses that operate as independent franchises, whether it's a muffler shop or a fast food outlet. The National Labor Relations Board seems to be trying to change the rules about how these franchises can be unionized. Bring us up to date on that.
Yeah, this is a really amazing story, and probably, if allowed to be implemented as the General Counsel of the National Labor Relations Board has ruled that it should be, will radically change the franchise model in America. And it really, I mean, that's a model that has created literally a very big, healthy part of our middle class, and is just a model that works.
Well, it's also a path forward for entrepreneurs and small businessmen who want to be able to take the model and the logo and the brand of a big corporation but run their own business.
Yeah, that's right. And so what's happened here is the General Counsel, Richard Griffin, who is a former union lawyer, has basically announced that they believe that a franchisor, i.e. McDonald's, is going to be responsible for the violations of their franchisees. And basically it relates to the labor policy. So if a franchisee in Paducah, Kentucky has a problem with an employee, the employee is going to be able to file charges with the union's help, of course, and not only at the local McDonald's store, but also in Oak Brook, Illinois, against the parent company. And this is just a dramatic change in the way these franchise arrangements have been interpreted. And it's simply designed to put pressure on the franchisors to encourage their franchisees to allow the unionization of their employees. And in the fast food industry, it's really an interesting model, Bill. What you get here is you get a large turnover of employees, and the employees, if they were unionized, would pay a one-time initiation fee, which is substantial, and then pay monthly union dues, and basically be gone after 6 to 8 months. And so the union would get this churn on initiation fees and union dues, and really have to provide little services to the workers of these franchisees, and it would be a huge revenue sleeve for them.
Sounds like a great deal.
Yeah, it really is a great deal for them. And again, it radically changes the way one particular successful model of entrepreneurship and small business has grown in this country. And the unions know it. This whole campaign over wages in the fast food industry is all designed to put pressure on these corporate leadership to encourage, quote unquote, unionization in this particular area.
What's the likelihood that the NLRB is going to succeed in changing the rules?
Well, I think they already have. I think they've actually issued a complaint against a parent company in one of these charges now. They're going to go ahead and enforce the law that way. I think you'll have to get into federal court and get the federal court to strike this down. It'll take time, but, that's one of the parts of the strategy for organized labor. They just start doing it, and then they basically, say, go ahead and litigate it, and we'll appeal it, and it'll take 4 or 5 years, and in the meantime, we'll start winning cases like this, and corporations, large publicly traded corporations like this, have some kind of threshold where they just settle out these cases, and that will just spawn a whole new series of these cases, and union officials will just continue to capitalize on that for more dues revenue.
We hear a lot about big money in politics, and the unions certainly seem to have built a great machine for collecting money from workers. How much do they spend influencing elections and lobbying politicians?
Yeah, Bill, we just completed a study last month using reports filed by the unions themselves. These are the reports they file with the Department of Labor and some of the political reports they would file with the Federal Election Commission. And we found that they self-reported about $1.7 billion just in the last 2 years, in this 2-year election cycle leading up to November of 2014.
Wow.
That mirrors what we found in the 2011-2012 cycle. Again, $1.7 billion self-reported. Now, we know, because of the investigations we've done and the lawsuits we've had against unions, that really, that's not all the money they spend on this either. It really isn't. This is just what they report, and they get away with it.
Well, there's a lot of in-kind political support, isn't there? Get out the vote drives and that sort of thing?
That's exactly right. In fact, one case that we took all the way to the U.S. Supreme Court, a case called Beck versus Communication Workers of America, that we won on behalf of workers here in Maryland and across the country. In the initial investigation of that case, we found the union could only prove that 19 cents of every dollar they were raising was spent on anything that resembled contract negotiation, grievance, or arbitration. Yeah, so, you start running those numbers. Organized labor is about a $20 billion a year business. You start running those numbers, and you see just how big of a political player they are.
Well, who's on the receiving end of all this?
Well, they obviously are very focused on one particular party. Generally, if you analyze their political contributions, which are really kind of just the tip of the iceberg of the type of financial support they provide, they give anywhere from 92 to 99.9% of their money to one particular political party.
Sounds like the Harvard faculty.
Well, yeah, certainly the numbers are very high, and they put in kind of that all-in bet on the Democrat Party for sure.
So, Mark, as I look toward the 2016 presidential campaign, do you think they'll be a big factor?
Absolutely. They will be a big factor. They are already a big factor, we believe, Bill. In fact, we just released an analysis of some of the LM2 forms of some of the biggest unions in the country, and we looked at it as the story about the Clinton Foundation and the Clinton Global Initiative are breaking over the last week or so. We looked at this in that context, and guess what? We found that union officials had contributed almost $2 million to the Clinton Foundation.
Wow.
And, the numbers kind of increase as we get closer to 2000 as Hillary announces for president. And it's kind of an interesting study. I think we've just kind of scratched the surface about what's there. I'm not sure why the union officials feel like they need to give to the Clinton Global Initiative. One union gave $500,000. Another union gave $400,000. Unions classified these contributions differently. Some said it was a political contribution. Some said it was a representational contribution, which means that even non-members of the union have to pay, are forced to cough up money to fund the Clinton Foundation. There'll be more on this story for sure.
Well, they're going to have to elbow the Saudi sheiks out of the way, too.
Yeah, this is an interesting story. I think there's more to be known there.
So, Mark, one of the things you work on nationally is the right-to-work movement. I know many states have enacted legislation to protect workers from forced unionization. What's the status nationally?
This is a really exciting time for right-to-work, Bill. We now have 25 states that have passed right-to-work laws, 3 in just the last 3 years. Indiana passed a right-to-work law in 2012. Michigan, of all places, passed a right-to-work law at the end of 2012. And just 2 months ago, Wisconsin became America's 25th right-to-work state when Governor Scott Walker signed the bill. It really is kind of exciting to see the interest in right-to-work and to see what I believe is a better understanding of what right-to-work does.
So give us a legal definition of what that means.
The right-to-work issue is really very, very simple. The laws on the books in 25 states protect a worker's right to join a union, but they will not contemplate and will not allow union officials to have a worker fired for failure to join or tender dues or fees. It's really that simple. There is not a right-to-work state in the country where a worker cannot join a union if they want to. There is not a right-to-work state in the country where a worker can't pay union dues if they want to.
Okay.
There is not a right-to-work state in the country where a worker can't participate in the union's political activity if they want to. But in all of the 25 states, no worker can be compelled as a condition of their employment to pay these dues or fees. That's the simplicity of the right-to-work issue.
How does economic growth differ in right-to-work states versus forced unionization states?
Bill, that's a great question, and the data is getting better and better all the time. What we find in the right-to-work states, that personal income, per capita personal income, are higher, job growth is better. The conditions for creation of jobs, for investment, for new jobs, and for the growth of jobs is getting demonstrably better in the states that have right-to-work laws. In fact, the 2 states that led the nation in new manufacturing job growth in 2014 were, guess who? Indiana and Michigan, the 2 newest right-to-work states. We know that private sector employment growth grows sometimes double the states that allow forced unionism. And, site selection experts, people that consult with companies looking to expand or relocate, will tell you that almost 50% of all of their clients who are looking to expand or invest in new states will not even consider a state that doesn't have a right to work law. And we're seeing evidence of that, for example, in the automotive industry. 78% of all automotive manufacturing activity in the United States now occurs in right-to-work states.
If you're a worker in a forced unionization state and you have to pay so-called agency fees to a union, don't you have some sort of right to deduct the amount they spend on lobbying?
You do. In fact, that opportunity for workers to get out of the political component is a result of one of the Supreme Court cases we won and representing employees that were confronted with this notion that on one hand, in order to maintain their workplace rights, they had to give up their political rights. We don't believe that's a choice that any worker should have to make. But in those states where you can be compelled to pay fees to a union, you can ask for a rebate of the money that the union says they spend on politics. And it's a hard thing to get to the bottom of. In fact, most of the litigation we have about 284 active cases as I speak to you today. And many of those cases are over the issue of what is or what is not required for workers to pay as a condition of keeping their job. One of the things that happens here, and this is a Hobson's choice bill that no one should be confronted with, in the states that don't have a right to work law, in order for the worker to get a reduction of the political part of their dues, they have to resign union membership. If they resign their union membership, they can't vote on the contract that governs their employment. They can't vote in union elections. They can't determine who's going to lead them in the union. All these workplace rights go away to protect their political rights. If they want to maintain their workplace rights, they must maintain their membership in the union. That means, quote unquote, they assent to the political activities, so they lose their ability to object to their money being used for political causes or ideas which they would oppose.
Well, what happens to bona fide union people? They really like the union, but they happen to disagree with which party that their bosses are giving the money to.
They can't get out of it. Like I said, they are confronted with the same choice, Bill. They have to give up their workplace rights in order to keep and protect their political rights.
So, Mark, the National Labor Relations Board seems to have an extraordinary amount of power in terms of interpreting the law and in terms of governing these union elections. How is that constituted, and how might it be reformed?
Yeah, Bill, this is really where the action is right now. In fact, it's almost encouraging in a way that we've now gotten this fight. We've got these three members, these three Obama appointees who are former union lawyers that serve on the National Labor Relations Board, kind of corralled in their headquarters down on 14th Street here in Washington, D.C., and they're the ones defending union officials' compulsory power more than anybody else across the country. The board was formed in 1935 when America passed what is known as the Wagner Act, when they basically said the federal government is going to manage union and management relations. The board is a 5-member panel. By definition, they are an independent agency. Board members serve for a 5-year term, so each year someone comes off, and they are the adjudicators of labor policy as it relates to our federal labor policy. They are nominated by the president, they are confirmed by the Senate, and I use the word confirm with my quotation marks around it because it's gotten interesting about how that process works. That's a whole other story. But it suffices to say that this board basically says this is the way we're interpreting labor law. And so what we've seen over just the last several months, a couple of major programs by the NLRB that radically changed the way labor law is enforced. One example is what's called an ambush election. They just promulgated rules that went into effect in April that basically say that the union, once they decide they want to unionize a company, can get private information about employees, their cell phone numbers, their work shifts, their home addresses, all kinds of information that allows them to target these individuals for union certification elections.
They can show up at your house?
Absolutely. And there are story after story of people who have come home from work and somebody's waiting in their driveway to hand them a union card. And sometimes late at night, they'll hear a knock on their door and 2 or 3 people will be standing out on their porch saying, hey, we're just here to tell you about the union. And we know from the cases we've litigated that many workers just sign the card so that these people will go away.
Wow.
And so this ambush election rule radically changes the way unions operate when it comes to organizing workers. It dramatically compresses the time frame of union elections from what was about 38 to 45 days on average, now down to as little as 13 to 15 days when workers are confronted with their vote. It allows union officials to get this private information about the employees, as I mentioned. And this we've now litigated. We just filed a case on behalf of 3 employees who are objecting to the release of their private information to union officials that they want nothing to do with. We've got that case in federal court. So we'll figure out how that goes as a defense against this new ambush rule that the NLRB has promulgated. These people are the primary movers and shakers when it comes to union organizing today in America.
Well, Mark, it sounds like you've really got your work cut out for you. Thanks for coming on the show and sharing it with us.
My pleasure, Bill. You're right. There's a lot of work to be done, but the good news is that we're beginning to win, and people are beginning to understand the simplicity of right to work and the individual freedom and liberty that it protects.
That was Mark Mix from the National Right to Work Legal Defense Foundation here on Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. Real Clear Radio Hour is produced in conjunction with Real Clear Politics, America's premier independent political website. Real Clear Radio Hour is a not-for-profit, donor-supported program. If you'd like to help us expand, please stop by realclearradio.org and hit the donate button or contact us to become a corporate supporter. That wraps up our show for this week. Join us next week, same time, same station. See you then.